Good morning, everyone, and welcome to this month's webinar where we're going to be discussing the Retained EU Law Revocation and Reform Bill. So before we make a start, we would like to introduce ourselves. And I'm Victoria Templeton, one of the HR Knowledge Managers here at HR Solutions, and I'm joined today by my colleague Sue Watson, Head of Client Services, and Rebecca Johnson, Marketing Manager. So together we'll take you through this subject. So Sue will be helping support with the polls, as well as a Q&A at the end, and Rebecca will be on hand to help with any technical questions or challenges. Hopefully we won't see any, but we've got Rebecca on hand. And because we've got lots of you that joined today, we've placed you all on mute. However, we do want to hear your questions, and no doubt there'll probably be quite a few, given that we have some developing news on this subject. So we'll do our best to answer what we know, but bear with us as well, given that the updates on this bill only came through late yesterday. So when you see this slide, this means we're at the end of the webinar and ready to take those live questions. And here's a quick run through of how you can submit your questions to us. So on the screen now you'll see the image of your GoToWebinar panel, which looks like this, and simply type in your questions in the question pane, and then we'll aim to read out as many as we can. And what we're going to be doing as well, we're going to be pulling together all the questions and collate and issue a Q&A sheet next week on all the questions that come through, and share some information further once we've had time to also digest all the news that came through on this bill, as I said last night. So but we will of course take as many live questions as we can. And when you see this slide, it means we're going to be running a confidential poll in which we seek your input. Just remember to not be in the full screen mode, because for some reason GoToWebinar doesn't operate the poll system whilst you're in the full screen mode. So just come out of that and participate. So let's get going. And so what I'm going to do today is take you through what the Retained EU Bill is and give you the latest update as of today. Now, we received news last night, probably about 4 or 5 o'clock. The government have made some announcements all to do with this bill. So we're absolutely bringing you the latest news on this bill from what we understand was communicated yesterday. So I'm going to be taking you through what the Retained EU Bill is in its latest form. I'm going to then give you the latest update. As I said, it will be as at today and will incorporate yesterday's announcement. And then what we'll also share with you is our own impact assessment of what we think will happen to the UK employment laws impacted by this bill. And there's already a couple of areas that we know what the changes are because of the announcement from yesterday. And then as usual, we'll finish off with your questions and answers. So please do submit these as we go through today's webinar, because it'd be really good to get your thoughts and questions on this subject. But just for context, before we get going, I think it's just important for me to say that in preparing for the webinar, clearly we've been closely monitoring this bill's progress through Parliament, reading many employment bulletins, legal commentators, and just getting an understanding of the bill. And obviously having read the bill itself, we've got the developments that came through, but ultimately it's all proposed, and so until the government can give us that exact clarity and confirmation of the areas that they're wishing to seek to amend and change, you know, these are all just, I guess, our thoughts based on what the research we've done and what we're hearing in legal commentators' updates and things like that. So of course, as I said, we've got some news from the government that came through yesterday, so there'll be some areas that we know for sure what they're going to, their plans are. So let's begin with a summary of what the bill is about and how much your understanding is. So we're going to run our first poll, and this poll question is about actually how much do you know about the bill? Could be not a lot. You may have a basic overview but unsure how it will impact your business, or you may have a good basic understanding and are aware of the key areas that could impact your business. So let me know your thoughts and we'll see what what's everybody's understanding is of the bill.
I think most people have voted now. Okay, I'll
Lovely.
close that poll and share the results with you.
So what do we have here? We've got 51% of you, not much of an awareness or understanding of the bill. So great. Hopefully by the end of the webinar, you'll be up to speed with absolutely all the latest developments. 45% of you have a good basic overview, but unsure how it will impact. Yes, so hopefully, as I said again, going through this webinar, we're going to talk through the areas where we think it could impact business. As I said, these are just our assessment and interpretations based on what we're reading and seeing from the bill. And 3% of you have a good basic understanding and aware of the areas it could impact. So hopefully lots to learn by everybody. So thank you for that. And then on to the next slides. So what is the retained EU law revocation and reform bill? A bit of a mouthful. So up until now, we've been able to retain EU-derived legislation because when the UK left the European Union, the UK and EU signed what's called the 2018 European Union Withdrawal Act. So what it means is that if the bill is passed, it would end the authority of EU law in the UK as it's currently drafted. So this bill, it proposes new legislation that would scrap legislation that comes from European legislation. But we had a development yesterday from the government, which we're going to discuss further in the webinar. And what it's proposing is that actually this bill would instead be a bill about the EU will remain, the EU law will remain binding in the UK unless it is expressly repealed. So rather than it being everything's automatically scrapped later this year, instead it's going to take the position of everything will remain binding unless it is expressly repealed. So hopefully all will become clear as we go through the webinar. So the bill will be amended so that it will contain a list of the retained EU laws that the government wish to revoke on the 31st December, and therefore anything that's not on that list will remain valid. So essentially it's about the UK government wanting to take the power and authority in order to make changes, revoke, amend pieces of UK legislation that have always been underpinned by EU law since the 40-year relationship has been in place. And the amendment we're going to see brought into the bill is effectively to include a list of those laws that are going to be revoked. So the impact of the bill is unclear at this stage because ultimately it's going to depend on what the government want to scrap, want to amend or retain. And moving forward, any European law that we hold on to is going to be known as assimilated law. That's what's been worded in the bill. So in theory, the bill has potential for significant changes to UK employment law and something that the UK hasn't seen in decades. The UK does have a long-standing history of providing enhanced employment protections compared to other Western world countries. And so I think the general view is that it's difficult to see how many of the UK employment protections that stem from European law could go back and regress to the position of when the UK was not in the EU, because we simply offer many enhanced protections, but of course it's not clear. It's also understood that the government does not intend to make significant changes to UK employment law because of it, although it's unclear, as I said a moment ago, about the government's intentions, because obviously we've not got that clarity, and so we're not clear on what significant changes means in practice. So the word significant is very broad and can be interpreted differently, but I mean, the government have committed to not making significant changes. Now, the current bill contains what's called a sunset clause, and that means there's an expiry date within it that would mean that everything's automatically scrapped, but there is an extension that sunset clause could be in place until the 23rd of June 2026, in which case it means UK legislation derived from the EU law will be abolished from this date, the 31st December, unless, of course, the government decides to amend or reaffirm. Now, there's over 3,700 pieces of legislation that needs to be assessed and a decision made as to whether the UK retain it, amend it, or revoke it. Now, the 3,700 pieces of case law and legislation, I mean, that's just the current count, because there's currently an auditing process going on to really understand how much legislation, European legislation, there is that's impacting UK law. And the breaking news that came through, there we go, my animation's not in order. The breaking news that came through yesterday is that there's an amendment to be put forward to remove this clause, so taking away the deadline. And if you think about the fact that we've got 6-7 months or so to go, and there's already at least 3,700 pieces of legislation that need to be assessed. I think previously there's been a lot of criticism as to whether there's enough time to obviously go through that due process to do that. So the breaking news yesterday was that that sunset clause will be revoked. Okay, so on this slide, I just wanted to indicate the areas of employment law that are underpinned by the European legislation, and it's believed, as I said, to be over, well, in total 3,700 at least, but that's not just employment, that's all aspects of legislation that impacts on agriculture, sports, media, you name it. All the UK legislation underpinned by EU law, but from an employment perspective, there's probably around 300 that relate to business and employment, including case rulings. So that, you know, there's a huge amount. And as you can see here, the areas of TUPE, working time regs, agency workers, discrimination, equality, and parental rights. Many of these will be underpinned by European legislation and case rulings. So in terms of the latest update, as I said, we've incorporated the developments from yesterday, and just bear with us, as obviously we need to get our heads around all the details that come through. So we will aim to provide some content next week around this, but for the purpose you know, of the webinar, what we know so far, first of all, is that the bill is at the latter stages of the parliamentary process. Just to give you some idea, then obviously it starts at the House of Commons most of the time, then goes through to the House of Lords. There's various stages in each. We're actually near the end of the stages, so it could become legislation fairly soon, and given the large scale of work that needs to be done, obviously there's a ticking clock going. So we're at the latter stages of the bill. It's at the House of Lords report stage. We've only just recently had the date confirmed, so from the 15th of May it's going to be at the report stage, and what that means is there'll be a detailed examination of the bill with further amendments put forward and voted upon. And obviously some of the breaking news yesterday included the amendments we're likely to, we will be seeing being added to the bill. So once the report stage has been completed, it will then go for a third and final reading in the House of Lords. Now, any amendments that will have been put forward need to obviously be agreed, and then both houses need to agree that final version of the bill, so the House of Commons and the House of Lords, and then it gets put forward to the monarch to become law. So we're fairly near the end of the parliamentary process. But the government yesterday confirmed that several changes, that there's going to be the removal of the sunset clause, and that will be put forward as an amendment. As I said, there's over 3,700 pieces of EU law that needs considering, and under the bill and this new amendment, all retained EU law will now stay unless a decision is taken to revoke or change. Now, the bill, as I said, has received criticism in the lead up to today because of the decisions that are going to be needed on all of these different pieces of legislation, and the argument that it could be rushed through. So what we'll do now is just look at those different areas of employment that could be impacted by the reform bill. And as I said, these are the areas that we believe is going to be impacted, and that we'll share our thoughts on how we think these will be impacted. And we're going to start with GP. So GP has been a fundamental business tool for decades. It goes back to 1981. It provides that continuity of employment following business transfer for service or for service provision change. And then it's also a significant piece of employment legislation that businesses have been using for years. So I think it's going to be unlikely that legislation will be abolished, but we are going to be seeing some changes, and we know some of those as announced yesterday. I mean, there could be further still, but from yesterday, what the government announced in their statement was that the legal requirement to consult under GP is going to be changing. So at the moment it is different to other consultation requirements, such as under redundancy. So the proposal really is to make this more of a simplified area of the law, the GP law, and the government have indicated that whilst there's already an exemption where consultation isn't required for businesses employing fewer than 10, the announcement yesterday was to remove the requirement to consult with elected representatives when there are fewer than 50 employees in the business and fewer than 10 transferees. So that came through yesterday in the statement. Now, looking at the working time regulations, I think this is going to see the biggest and most significant change from what we know. So the working time regulations stem from the Working Time Directive. It sets out our rules on working hours, rest breaks and annual leave. So really it's a piece of health and safety law. It's been in operation since 1998, and it's there to protect the health and safety of workers. So we do think there's going to be some significant changes to this, and it is a significant piece of legislation with several European case rulings that have altered it over the years. So it's unlikely they're going to be abolished because they're so significant and they're in place to protect the health and safety of workers. And so to do so would be a huge significant step back in worker protection. But there will be changes, and we know some of those as announced yesterday. So we're going to take a look now on where we think those changes are going to be. So the government here, in their statement here, go back. Let's see if I can pause that. Sorry. So in the announcement yesterday, Sue, are you able to pause that at all, or Rebecca? Right, here we go. I'm sorry about that. So the government announced yesterday, and it issued a policy paper, and within that policy paper is a section all to do with reducing the working time regulations. And it says that the working time regulations, which are derived from retained EU legislation, provide a number of valuable worker protections. However, these regulations place disproportionate burdens on business, specifically in relation to recording working hours and other administrative requirements. And we intend to reform them this year. We'll be consulting on proposals to improve how these regulations work without affecting the rights that really matter to workers. And that's from their policy paper issued yesterday called Smarter Regulation to Grow the Economy. And so what we know from this paper is that the government are proposing two things. So removing retained EU case law that imposed time-consuming and disproportionate requirements on business for working hour records to be kept for almost all members of the workforce. So this is going to cut red tape for businesses and help them save $1 billion per year while protecting the rights of workers. So that's going to be significant for obviously the record keeping of all your workers and their hours. And then the second one is about reducing administrative burden and complexity of calculating holiday pay. And holiday pay is always a tricky subject area. There's been lots of case law over the years. And so what the paper goes on to say is that we propose introducing rolled up holiday pay so that workers can receive their holiday pay with every pay slip, and merging the current two separate leave entitlements. So that's your normal holiday and in additional holiday into one pot of statutory annual leave while maintaining the same amount of statutory leave entitlement overall. So what that simply means on that second point is, at the moment as it stands, you've got your 4 weeks of annual leave that's your normal annual leave, and then you've got 1.6 weeks that's your additional annual leave. And what that means is there are technical differences because it determines your rules in your holiday policies. So carryover of holiday year can't be the full combined, for example, at the moment. You can only carry over one element of it. So there's going to be changes with that because ultimately you're going to be moving to one pot of a holiday. We don't know exactly what that looks like. We haven't got the detail, but they were proposing to move away from having the two elements of holiday and just having that one pot. Let me see if I can pause this. Okay. So there are some other possible ways the government may change the working time regulations. We haven't got a lot of detail, nothing's been confirmed. So on this slide, it's, I guess, based on a lot of speculation and research on legal views that we're reading about, and obviously people's implementation of the regulations over the years. So if we first of all think about holiday pay, it's a really interesting one. As I said a moment ago, we've seen many case rulings, but for those of you that remember, there was a European case ruling of Locke versus British Gas. And since then, UK employers have been required to implement this European case ruling where they have to calculate holiday pay based on actual earnings that include overtime, bonus, etc., rather than just basic pay. And so that's one area where we think we're going to see a change around the working time regulations in reverting back to the UK's position of prior to this case ruling. As I said, this is all, I guess, speculation and just research, but that's been a piece of case ruling that has been quite significant for many businesses, and obviously the costs that go with it. Second one is around holiday carryover. This is another area of UK law that's been impacted by European court judgments. And so in the case that I've highlighted here, I'm not going to pronounce it, but I've highlighted it in pink for you. But in this case, it basically means that EU member states have been not able to prevent workers from have been able to prevent workers from taking annual leave during periods of sickness leave, provided they can permit to take them at some of the time, i.e. carry over holiday into the next holiday year. So there's some thinking around whether overturning that position and reverting back to the UK's original position of not allowing carryover into the holiday year when on sick. The Harper Trust and Basel case ruling is always an interesting one, and always still causes a lot of debate, discussion, and questions. But for those of you that are familiar with the case, this is the one that confirmed how you manage holiday pay when you employ part-year workers or workers with irregular hours. So now, this is a case that was challenged on the operation of the working time regulations rather than the working time directive. And it's a significant difference because it means that the ruling and the judgment was challenging a piece of UK-based law rather than one that's underpinned by EU law. And the holiday pay ruling in this case was also focused on the Employment Rights Act of 1996 and how you calculate a week's pay, which isn't EU law. So the EU reform bill will have nothing to do with the Harper Trust ruling because it's underpinned by UK law, not the European law. So I just put that in there because I think there's been a lot of interest and I guess thoughts around making improvements on the back of that judgment because it's still a confusing subject area, and I think perhaps there will be something that we see on that because there's a separate consultation going on anyway by the government in how they calculate. But from an employment perspective under the EU reform bill, that's not affected by the bill. We then have case rulings that relate to rest breaks, and back in 2015 there was a significant case ruling. This is the Tyco case, and for anyone that employs mobile workers, so there's no set permanent location or base, but where there's mobile workers, then this ruling confirmed that the time spent at the beginning of the day and at the end of the day amounted to working time, because essentially the employees were carrying out their duties over the full duration of the day. So we could see some developments on how working time is calculated or considered. We shall have to see. And then the maximum 48-hour week. So I've touched on that a moment ago. This is another area of the working time regulations. It's very much seen as red tape to businesses, and in practice and in reality, probably not necessarily managed or implemented. The government view this as an administrative burden, with obviously the records that are required to be kept, time intensive to administer. And if we think about the government and communications that have come out since the pandemic in terms of the need to focus on the UK economy, raising productivity levels, we've anticipated the government have probably wanted to do something around this, and there has been talks about scrapping the 48-hour week entirely. Obviously the announcement yesterday was about the records and the record keeping that you must maintain to evidence that you're complying to that, but we'll see in the coming weeks what that may mean to any 48-hour work limit. But there's a reasonable chance that perhaps that rule could go. Who knows? But definitely there's going to be some changes to the administration side. And then if we move on to agency workers, in 2008, the EU introduced the European Agency Workers Directive. They give the agency workers that equal basic employment conditions to those who are compared to those who are recruited directly by an employer, obviously after they've got the 12 weeks of working for that employer. So consequently, the UK then incorporated that directive into UK domestic law, and that's what you have, the 2010 Agency Worker Regulations. So they've been in place for 13 years, and actually I'm sure you'll probably also understand or probably aware they've never really been popular with businesses, seen as red tape, burden, and so they're very, very unpopular, and they've really not been liked at all since the implementation. So there is a strong chance that given this opportunity to review our UK laws that are underpinned by EU legislation, then this may come in and be either amended or even actually abolished. We know in the past the government have talked about wanting to change or remove this. It's never happened, but obviously we've got the opportunity now, whilst we're looking at all European-based UK legislation, to actually perhaps do it now. So there is the potential that this actually gets abolished, or if not, significantly amended. And if we think about discrimination, so our discrimination laws have also come about over time. Either they're a mix actually. Some are just purely UK specific domestic laws, such as your sex, race discrimination. Other parts of our discrimination laws have been introduced by the EU and therefore adopted in the UK into domestic law, and they're the ones such as age and religious discrimination. But regardless of this, I think it's going to be very unlikely that we're going to see any changes to these protections. As I said, the government have a good history of offering enhanced employment protections. Generally, as a country, we've had discrimination laws in for decades, so it's very extremely unlikely that there's going to be any changes to protected characteristics. Of course, we have other areas of discrimination law, such as part-time worker regulations, fixed-term worker regulations that are based on European legislation. But as I said, because we've got those high standards in discrimination laws, I think it's going to be difficult to see any significant changes to those. And then what I would say is that there has been speculation on how the UK deal with compensation payments in discrimination claims. There's been talk in the past around putting a cap so that they mirror how we award in unfair dismissal claims. And so there is a question actually, because there's the opportunities I've said to look at all UK law that is underpinned by EU, whether there's an opportunity to introduce a cap on discrimination compensation payments. So that's a possibility. Parental rights, again, many of them stem from EU laws and directives. I think it's difficult to see how these would be changed. As I said, because we have strong protection employment rights around that. The one thing to flag is that when a tribunal deals with equal pay claims, then there's a treaty, European treaty, that's relied upon. The equal pay for equal work is actually in Article 157 of the Treaty on the Functioning of the European Union, abbreviated to TFUE. So it'll be interesting. It's unclear, of course, but it'll be interesting to see what happens now in how our UK equal pay claims are dealt with, given that there's that reliance on the European treaty. So we're going to now run a few polls. So let's get the first one up, and it's really about from the areas that we've talked about, which one do you think is likely going to impact your business?
And you can select more than one, I think, of this, can't you?
I believe so.
We appreciate some of you may have woken up to all these changes, so takes a while to absorb.
Yeah, plus we don't have obviously a lot of detail, but only
no,
I guess guesswork, isn't it? But
okay.
Okay.
I think with that, I'll close that one and share the results. There you go.
Okay, so 39% GP, 57 family friendly, 51 discrimination, 37 agency, and 72 is a biggie, working time regs, and that's where we're perhaps going to see the most change, aren't we? So that's interesting.
Yeah. Shall I move on to the next one?
Yeah. And the next poll is, from an operational perspective, which one would you like to see abolished?
You can select them all.
Some interesting stats starting to show.
Mm. At the moment, not the one with the biggest impact.
No.
Okay, I'll
Yep.
close that poll and share the results.
Okay, so 45% for the agency workers, which probably doesn't come as a surprise. And then Chupi actually probably higher than I thought. I don't know about you, Sue.
Yeah, absolutely. Yeah.
It's overtaken the working time regs, so that's at 37%.
Mm-hmm.
Yeah, and a few have voted on the family and the discrimination areas. Ah, interesting. Okay, so yeah, interesting. Thank you.
I'll just move on to
So
the next one.
This one's specifically about agency workers. First of all, do you use agency workers?
Yes, with the current recruitment kind of issues, we wondered whether this might be higher than perhaps in the past, but it's looking fairly evenly balanced actually.
Yeah. We've only had one 50-50 result, haven't we, on the polls that we've
yes.
managed.
Right, I'll close and share that one.
Very close. So 54% of you do use agency workers. Okay, so this links in then to our next poll. So for those of you that do, would you like to see the abolition of the agency worker regs?
Okay.
Yep.
I close that one and share the results.
70%, yeah.
Overwhelming, I think.
Yeah. Yeah, it's not been taken well, has it, at all since its introduction? Yeah, okay, thank you. So,
yeah.
I think that's the last with that poll. So now over to questions, Sue. Excuse me.
Well, we have one
any.
question just for clarification, which is I think might be quite useful anyway. Somebody's asked for clarification on the rolled up holiday pay. So
Okay.
this is when the ruling at the moment, and the government website is still saying this, is that holiday pay should be paid for the time when annual leave is actually taken, and that an employer cannot include an amount for holiday pay in the hourly rate. So some people have used it so that they calculate what the paid holiday entitlement is for the year, and then they include it in the hourly rate. So they say you've been paid for your holiday. It's common with 0 hours contracts, isn't it, and casual workers. And at the moment, it is not legal to do it, but the implication is that they will actually introduce it.
Yeah.
Which I think some people would find easier, but we're still kind of trying to persuade people not to use it that do. It's quite common in the hospitality industries, particularly. But yeah, it looks like they are actually going to concede on that one and introduce it. I think we'll have to identify it separately on the payslip so that it's clear that the holiday pay is being paid and it's not just employers trying to get away with it with a slightly enhanced hourly rate. So you will have to still calculate the amount due and identify it separately on the payslip, I'm pretty sure.
Yeah.
But yeah, we wait for the clarity, don't we?
Yeah, and I think holiday is probably an area we're going to see some significant changes on a practical level, aren't we? Then if the rolled up holiday pay, plus we've got separate to this, like I mentioned in the webinar, the consultation that's going on how to calculate holiday pay for part-year workers and irregular workers, which is, as I said, separate to the EU piece, but nevertheless the government are keen to get something in place on the back of the Harper Trust ruling. So I think we're going to be seeing some changes to how we manage holiday, which obviously will keep you all posted and informed on our website knowledge base, for those of you that have the knowledge base.
Absolutely. So yeah, so I think that's the concludes the live questions.
Okay. Okay, brilliant. Let's move on. So here we go. So just to sort of bring the webinar to a close, just want to run through some of the slides in terms of how we may be able to support your business. Obviously, we offer training courses from a management point of view, so everything ranging from effective communication skills through to ILM accreditation. We've got everything that also looks at the entire employee life cycle, whether it's disciplinary agreements, performance, etc. So if you're looking to, if you've got some new line managers in place, new starters, then and you're looking for some training, then we've got a QR code there. Please visit our website and take a look. We also run health and safety courses, so we're currently looking at scheduling courses to do with fire safety, food safety. Mental health is a biggie. It's massive because we're seeing more and more queries come through on mental health. We're running a mental health webinar actually in a couple of weeks, but we also offer mental health first aid training and mental health ambassador training. So if any of that is of interest to you, then again, there's a QR code for you. And I mentioned webinars, so the mental health one is on the 19th of May. It's an additional one for the month. It's at 10 o'clock, so it's a Friday this time. And myself and Dom, so Dom's our Senior Health and Safety Consultant, we're going to be taking your questions. So you can submit any questions you like on mental health in the workplace in advance when you register. And we'll be taking live questions as well during the seminar, the webinar. And so we'll be coming from it from both a health and safety perspective and a HR management perspective of how you deal and support people that struggle with mental health at work. So, and that's going to be held during Mental Health Week. So do join us for that. And then back to our normal schedule of webinars. So the June webinar is all about 4-day working weeks. You know, we've seen the results conclude on the survey that the national pilot scheme. So we're going to be talking about that and how to go about implementing and the benefits and negatives of doing so. With recruitment still being a challenge, then July is all about how we can take a different approach to recruitment and see if there's any different ways in which businesses can get their best talent. And then August is looking at building skills and capabilities. So building on from the recruitment one, we're looking at how building skills and capabilities can actually help overcome some of the recruitment challenges simply by recruiting from within. And then September's about how to become an age-friendly employer, and October in ready for some changes that we're going to be seeing in terms of immigration developments. We're going to be talking about what those developments are and how they may impact employment. So these are all free to attend. Simply go onto the QR code, visit our website. If you're a knowledge base user, then obviously you can register through the knowledge base as well. And we'd just like to run a final poll with you all, just to see about how we may be able to help support you and your business through any of the services that we offer. So whether that's our HR services, health and safety services, the HR knowledge base, which is our portal where you can get policy templates, template letters, checklists, guidance, and all our articles as well. Payroll and of course training. So do let us know if you'd like us to get in touch. And we can follow up with you on those services. And then when you're ready, let me know when I can move on, Sue.
Yeah, just collecting those responses in at the moment.
Okay, perfect.
Okay, I'll close that now. If
Okay.
But you can always contact us through the usual routes if we've not captured your interest on this particular poll.
Yeah.
Yeah. There you go.
So thank you. So, right. So that just leaves me to say thank you, everybody, for coming along to our webinar. We've frantically incorporated the updates from yesterday late afternoon, so appreciate you bearing with us. I am going to provide some content, and we'll get that published on our knowledge base in our and website next week, so do look out for that, all to do with the latest on the bill. And if anybody's got any questions, obviously do get in touch. So thank you everybody for joining, and thank you Sue and Rebecca for supporting and helping with the webinar.
Thank you.
Thank
Victoria.
you, everybody. Bye.